New Jersey is proposing a whole bunch of restrictions on their new carriage regime dealing with Americans that want to carry guns in New Jersey. We've talked about this in other videos. Now we're going to break down specifically how their carriage rules about who qualifies to get a carriage license likely runs afoul of the Second Amendment and NYSERDA versus Bruin. This is a longer video, a very detailed, geeky video. I'm warning you now, but it's important not just if you live in New Jersey. It's very important if you live in New Jersey, but even if you live in other states, because again, it's extremely important that you understand the constitutional and analytical framework to analyze these kinds of questions, because you never know when these kinds of nonsense laws may be coming your way. Certainly the anti-gunners want all these kinds of laws to be all over America if they had their druthers. Good news, a lot of these will probably be unconstitutional. Stay tuned, we'll talk about it in a second. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and New York Times best-selling author. If you haven't subscribed to the Four Boxes Diner Second Amendment channel, please do so and show your love for the right to keep and bear arms. Okay folks, here we go. Talking about New Jersey still. We've talked a lot about this new law that's being discussed in the New Jersey legislature. Don't know what the final law is going to be, but I want to make some observations about the draft law that I read, which is this law here, which goes on for dozens and dozens of pages in super small type. But don't worry, there are a handful of geeks out there that will actually read word for word and punctuation mark from punctuation mark to try to bring to you what appears to be going on in places like the state of New Jersey. Today, I want to talk specifically about the rules that they're trying to impose on who gets to carry guns in the state of New Jersey. So to do this, I'm going to put this into a framework, then I'm going to give you what I think is the relevant law, and then I'm going to apply that law to the proposed legislation in New Jersey. Again, the framework first, the relevant law as I see it, and then I'm going to apply all of that to the specifics of the New Jersey law. Okay, here we go. To begin with, we know that the relevant law for determining whether or not someone can carry a gun in the United States under the Second Amendment and all that stuff, of course, is the Second Amendment itself coupled with the U.S. Supreme Court decision in NYSERDA versus Bruin. We all know that NYSERDA versus Bruin dealt with the right of the people to carry guns, specifically the right of the people to bear firearms, to bear arms, because the right to keep means the right to possess, and the right to bear means the right to carry. So the U.S. Supreme Court says we have the right to bear arms in the United States. That means the right to carry handguns outside of our homes for the purposes of public self-defense in public. That is a law. It specifically went on and says that the New York law, which said that the only people that were allowed to carry guns in public for self-defense were, well, law enforcement, of course, because they're special, and also those civilian, non-law enforcement individuals in New York that could show a special need. They were celebrities, they were at risk of stalkers, some other unique circumstance that made them special and separate and apart the common populace that just wanted to carry guns for self-defense. The U.S. Supreme Court says that was verboten, that was not allowed. All Americans benefit from the Second Amendment, and therefore all Americans, law-abiding Americans, have the right to carry guns outside the home for the purposes of self-defense under the Second Amendment's right to bear arms. Okay, that's where it is. So basically the Supreme Court says that the Second Amendment does not require you to go, mother, may I please carry a gun outside the home to the government. The Supreme Court said that's not how it works in America. It doesn't work for the Constitution. You don't have to go, mother, may I please go to Mass to pray to God. Mother, may I please take communion. Mother, may I go to the parade to protest Joe Biden. Mother, may I, do a protest. Mother, may I, can I post a blog? Mother, may I, can I tweet something out about Donald Trump or whatnot? It's not how any other part of the Constitution works. And the Supreme Court says that also applies to the fundamental right to keep and bear arms of the Second Amendment. With that said, what happens next? Now, the Supreme Court says that the only that states can require shall issue permits. They can require permits provided that, and this is the key, those shall issue permits meet three criteria. Basically, they have to be objective, not subjective, subject to the discretion of some government official. It has to be objective, it has to be a definite standard, and it has to be narrow. It can't be a whole huge crazy sort of set of circumstances. Basically has to be, again, objective, narrow, and definite. That's what the Supreme Court says. That's the standard to determine whether or not you can carry a gun or not. Nothing more exotic than that. Now, you're going to see how New Jersey runs afoul of that in multiple ways. Now, let's go on and talk furthermore about the next step. The Supreme Court also says that there needs to be some sort of historical analogy to show that there was some, history, gun control law in 1791, which is the year the Second Amendment went into effect. And again, at 1791, the Second Amendment goes into effect. Don't get confused by the anti-gunners who are trying to argue that the relevant time period for proven historical analogies or historical analogs is 1868, when the 14th Amendment was adopted, because the 14th Amendment only took the Second Amendment and the rest of the Bill of Rights and effectively applied it to the freed African-American slaves. They didn't change the scope. At least they didn't shrink the scope of the Second Amendment. You could argue maybe they expanded the scope, but they certainly didn't shrink the scope of the Second Amendment below what it was in 1791 with the adoption of the 14th Amendment. Although, the anti-gunners, we've talked about this before, the anti-gunners want to use the late 19th century as the basis for showing historical analogs of modern-day gun control laws to uphold them. Why? Because there's a lot more gun control laws in the late 19th century, specifically the black codes, which were Southern-style gun control laws designed to prevent blacks in the South, the freed slaves from the South, from being able to keep and bear arms. So the anti-gunners, and as best I can tell, want to use those laws to say, see, these laws existed in the late 19th century, therefore they're historical analogs and can justify modern-day gun control laws today, as opposed to back in 1791, where there are very few gun control laws at all. Okay, so let's carry on. Now, what did the Supreme Court talk about carriage? Let's discuss carriage. So here's the key. Let me tell you, first of all, what the anti-gunners are trying to do, and then I'm going to explain to you why it can't work under the law. What the anti-gunners are trying to do is they're trying to shift their strategy. How are they doing that? Up until NYSERPA versus Bruin, the Supreme Court, the anti-gun movement, states like New York, New Jersey, California, they wanted to use discretion on the part of government officials. It could be a judge, it could be the cops, law enforcement, could be a licensing official, whatever it is. Places like New York and New Jersey, the anti-gun blue states, wanted to let their government officials have the discretion, which means the subjective decision-making authority, to opine, make an opinion about whether or not you and I needed to carry a gun. That was where the discretion was being exercised. Did we need to carry a gun? That was the question. And they made a subjective determination on a case-by-case basis who needed the gun and who didn't. That was the idea. Supreme Court says, no more, you can't do that. So what the anti-gunners are now doing, this is extremely important for you to understand what they're doing, because if you don't know what they're trying to do, you will not be able to stop them. You need to know the play. If you know the plays the offense is going to run in football before they run it, you are much more likely to be able to stop it on the defense than if you don't know what's coming. The good news is if you watch the Four Boxes Diner, I don't just report the news. Anyone can do that. I can read a CNN article and opine on it like anybody else. But why you turn in the Four Boxes Diner channel, as I see it, it's because you want to be able to look down the chessboard. You want to look into the future and allow us to try to predict what's going to happen next, because only by being able to predict can we maximize the opportunity to stop it and protect our rights. That's how I see it, and that's, I think, a major role, as I see it, of the Four Boxes Diner, not just regurgitating, today's news, which I can do, but I think you guys can read the newspapers as well as I can, so I don't generally do that. Okay, so let's move on. So what the anti-gunners are doing is this. They are going from trying to exercise discretion and who needs a gun, which is what they were doing before NYSERPA versus Bruin. Now they're shifting their strategy. Now what they're doing is they're trying to exercise discretion. They still want to use discretion. They're not going to be allowed to do it, but that's what they're going to try to do. They want to exercise subjective discretion on the part of government officials to determine, ready, who is good enough to have a gun, right? They've gone from who needs a gun for the purposes of public safety and for self-defense. Now they're shifting it. Okay, we can't do that anymore. Now we're going to go to who is good enough to have a gun. Now, how do they argue this? What they're going to argue is to say that, well, the Supreme Court says that the only people that are entitled to guns is law-abiding, law-abiding good citizens, something like that. Law-abiding, citizens with good moral character, which is really just basically saying law-abiding citizens that are not criminals and all that. That's all they're really saying. But what the anti-gunners are trying to do is we now get to drill down and do all of this investigation. We need to get personal references. We need to interview you. We need to look at your social media accounts. We need to do all sorts of investigation of your background to determine, are you a good enough person, a good enough American, in our opinion, to be able to carry a gun. And you'll see exactly the language that I'm going to point to from New Jersey. That's exactly where they're going, because you'll see the language in just a second. Okay, now this is not going to be allowed. And why do I say that? I want to read from you, and now I'm going to tell you what I think is the relevant law from Nysurpa versus Bruin. And I want to give this to you so you have the relevant sections of the opinion, because the Nysurpa versus Bruin decision is I don't know, like 60, 70 pages long. It's very long, and then you got dissents and everything else. So I want to break down what I think is the critical language. So here is the key, the first of the key language. We already know and gone over the fact that the Supreme Court says that a criteria for show issue permits must be definite, objective, and narrow. That's the first quote. That's in the opinion, right? That's number one. But it goes beyond that. This is what Justice Kavanaugh in his concurrence points out, why New York's regime is unconstitutional. And you'll see what I'm saying. This is an extremely important point I'm about to make. This is an extremely important quote that you must remember if you're fighting over objective criteria for shall issue permits in places like New York, places like New Jersey, places like California, places like Massachusetts, so on and so on and so on. Here's what Kavanaugh writes. New York's regime was, quote, constitutionally problematic because it grants open-ended discretion to licensing officials. I'll read that again. New York's regime was, quote, constitutionally problematic because it grants open-ended discretion to licensing officials. And, that's right, not my language, Brett Kavanaugh's language, and, continues on, and authorizes licenses only for applicants who can show some special need apart from self-defense, close quote. That is the point. Kavanaugh, in his concurrence, signed on by Roberts, specifically points out that there were two problems with the New York law. Not one, two, and this is very important. I'll tell you why in a second. It's very important to understand this, that Brett Kavanaugh and Justice Roberts in the concurrence says that the two problems were, first, that the law granted open-ended discretion to licensing officials, which is exactly, by the way, what New York is doing now again, and what New Jersey is now doing, or what it looks like they're going to do. They're going to grant open-ended discretion to licensing officials to no longer figure out, do you need a gun, but are you good enough to have a gun? Are you a good moral citizen, in their opinion, subjectively, in their discretion, that you're allowed to carry a gun? That's what they're going to do. But remember, Kavanaugh has two problems. One is open-ended discretion, and the second one is that the applicants had to show a special need, separate and apart from ordinary Americans for the purpose of self-defense. This is critically important to understand this distinction. And why is that? Because if you're not careful, the anti-gunners, and I already see it in their papers, I already see their arguments, they're already saying this, they're trying to conflate, they're trying to combine, to blend together these two problems. They're trying to say that the problem with the New York law, as the Supreme Court found, was not twofold, it was onefold. They're trying to say the problem with New York was that they required the showing of a special need. In New Jersey, that's called justifiable need, or I think it's called justifiable need or something like that. In New York, it's called proper cause. It's all the same thing. Basically, you have to show special need over and above ordinary Americans for the purposes of carrying a gun outside the home. The Supreme Court said no. So what the court's saying is we can still, what the anti-gunners are saying is that we can still exercise discretion as to who carries a gun. We just can't consider whether or not they need to carry a gun. That's no longer on the table. But we can still exercise discretion when it comes to, are you a good enough person? Are you a good person? Are you a moral person? Do you have good judgment? Are you law-abiding? Blah, 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 blah. All this is subjective and open-ended. Again, this is not allowed. Why? This is not what I'm telling you. This is what Brett Kavanaugh wrote in Nysurpa versus Bruin. Again, 2 points. Constitutionally problematic because it grants open-ended discretion to licensing officials, which is exactly where New Jersey is likely going to go. That's what they're trying to do. Do not forget this critical point in the Kavanaugh concurrence. Beyond that, here's exactly what they're also saying. This is Brett Kavanaugh, also in Nysurpa versus Bruin. He points out that the 6 states, he specifically references New Jersey, in fact, because he says, quote, the 6 states which includes New Jersey. Why? The 6 states, including New York, potentially affected by today's decision, may continue to require licenses for carrying handguns for self-defense so long, ready? So long as these states, including New Jersey, which is one of the 6 states they're referring to in that opinion, so long as these 6 states, including New Jersey, employ objective licensing requirements like those used in the 43 shall issue states. Objective licensing requirements. Not my language. This is Brett Kavanaugh and John Roberts' language in Nysurpa versus Bruin. That's what they say. Now, when we talk briefly about different things that New Jersey is asking to be considered, personal recommendations, maybe social media accounts, although they don't seem to be talking about that now, but I'm sure they're thinking about it. I'm sure they'll weave that in somewhere. That's my guess. Personal interviews, all these subjective judgments. It obviously, in my view, is going to violate what the Supreme Court specifically said in Nysurpa versus Bruin, included in the Brett Kavanaugh, John Roberts concurrence supporting the overall decision. Okay, so let's go specifically now. Now that I've just given you the analytical framework, right? I've given you some specific language from Nysurpa versus Bruin that you need to know about. I read the opinion for you, so you don't have to, although you should all read it. It's very informative and interesting. Now, let's talk about the New Jersey stuff. By the way, I'm flagging a lot of problems with this proposed New Jersey law. I can't identify every single one of them. I can identify every single one of them, but you're going to be really, really bored if I spend 4 hours doing these videos, breaking down every single ampersand and every single comma and all the different errors here. You're going to hate me if I do that, so I'm not going to break it down at that level. I'm going to give you the highlights, but just because I omit something or don't mention it does not mean it's good to go. It's just that, I had to pick and choose here because, there's a lot going on in New Jersey and I wanted to hit you the highlights so you learn about it. And then, of course, you can take my analysis and read it yourself, the proposed statute. Okay, so let's turn to the New Jersey law specifically. To begin with, the proposed bill, as I read it, gives the state open-ended discretion, which is clearly not allowed under Bruin. For example, here is what they say. New Jersey can deny even a purchase permit. Like, they actually have purchase permits. That's a whole separate issue. But they have the right, in their opinion, they have the power to deny someone the right to purchase and also the right to carry if, quote, ready? Does this sound objective to you? Does this sound objective to you? Let me read it to you. Quote, someone known in the community in which the person lives as someone who is engaged in acts or made statements suggesting the person is likely to engage in conduct other than justified self-defense that would pose a danger to self or others. What is the standard? I mean, what does this even mean, right? This basically is, as I see it, this is outsourcing the veto power over whether or not you can carry a gun in New Jersey and get your license to disgruntled neighbors, okay? What do you think Donald Trump's neighbors in New York would do? Or, if somebody went to Donald Trump's neighbors and said, hey, can you carry a gun, blah, blah, blah. I'm guessing a lot of those liberals in New York, I know Donald Trump now has moved to Florida. I get that, but you get the idea. Now you're outsourcing a lot of the stuff to your disgruntled neighbors and other people in the community that maybe don't like you. It's almost like the red flag law where your neighbor can call up the cops and complain about you. This basically allows neighbors to do the same except deny you the ability to have a gun. It's not going to fly because, again, it's the opinion of the neighbors, it's the opinion of the police, it's the opinion of the licensing official. None of these are narrow, definite, or objective. These are all opinions. These are subjective. To me, it can't fly under the law. But let's continue on. Now, the next point is that the proposed bill in New Jersey on page 6, as I have it, indicates the disqualification of a person to carry a gun if they are, quote, found to be lacking the essential character or temperament necessary to be entrusted with a firearm. Well, who gets to determine whether or not I have the essential character or temperament to carry a firearm or to possess a firearm or to buy a firearm? That's a subjective decision, which again, the Supreme Court says can't be subjective. It has to be, it's like a NICS check. Do you pass it? Do you not? Is it approved or is it not? I know NICS checks are not perfect, but you get the point. It's objective. It says, approved or declined. Okay, it's like a red light. Is it green or is it a red? One or the other. That's what it is. So that's what you say. Now, what does that even mean? Essential character or temperament. What is essential character, temperament necessary to be entrusted with a firearm? Well, obviously, if you're an anti-gunner in a place like New Jersey, you think no one's allowed to carry a gun except the government, right? So certainly every anti-gun voter in America and every anti-gun Democrat in America would find that all of us watching this show and Mark talking about the show would lack the essential character or temperament to touch firearms, right? Every deplorable, everyone that worked on the Trump campaign, yeah, that would be me, 2016. Yeah, all of us, 150% today would be considered deplorables. We'd be considered insurrectionists. We would be considered, who knows what else they'd call us. I've lost track. I'd be clinging to my guns and religion, right? On and on and on. So the point is, no one on the anti-gun community is going to think that any of us has the essential character or temperament necessary to be entrusted with a firearm, because if we were trustworthy, none of us would actually like guns. We'd be like the anti-gun community. We would have good judgment and not like guns. We would have good judgment and want no guns like they have in Europe. Okay, but let's move on. The next problem, of course, as I see it, is that they also require personal references. Yet again, what is the point of the references? You're asking people their opinions about you. This is not objective, this is subjective. And also, let's go back to the historical analog point, which I haven't hammered home enough here. Is there a historical analog in 1791 where you had to get personal references to be able to exercise any constitutional right, including the Second Amendment? Not a one. I don't think there's a single example that they can point to in 1791 of a historical analog law that shows that someone had to get a personal reference or somebody vouching for you in order to be able to own a gun or buy a gun or make a gun or any of that stuff. So again, I think that's also going to fail here. And as to the purposes of law enforcement interview, and they say that, here's what it says on page 16 of the bill. It gives law enforcement the authority to, ready, interview the applicant, that's you if you want to carry the gun, and to interview the references, your references, and to make inquiry about the applicant's history or character. Again, for what purpose? Let's think this through. So a police officer interviews me. He interviews, the 4 people that vouch for me. He interviews other people that are my neighbors. Then what else he does? He then looks at all, my history and character. He talks to other people. What is the ultimate outcome? He's going to form, ready? Here's the key. He's going to form an opinion. An opinion. That opinion, by definition, opinions are by definition not objective. They're subjective. It's my opinion. When I say it's my opinion, that's what I'm saying. It's subjective. It's not black and white. It's not objective. And that, therefore, if you read not me, but Brett Kavanaugh in the Supreme Court, it specifically says, again, the statute has to employ, quote, objective licensing requirements. That's the Supreme Court. That's in the opinion. That's Brett Kavanaugh's concurrence, quote, objective licensing requirements. None of this stuff dealing with moral character, justifiable need, any of this stuff is objective. This is all subjective and discretionary and likely to violate, in my opinion, the NYSERPA versus Bruin and the Second Amendment. So is there anything else on this long? And I'm going to give you the language. I'm going to sum up here. The language that you can look at from this proposed statute that proves my point, that they're shifting from the discretionary use of do you have a need to are you good enough? Here's some of the language. Okay, on page 6 of this proposed bill, which I'll put down in the description, they say who may obtain a gun purchase permit, carry all that. You have to have good character and good repute. Okay, good character and good repute is one example. Now that's one language. They also say that a person cannot suffer from a physical defect or disease which would make it unsafe for him or that person to handle firearms. One wonders how the Americans with Disabilities Act will treat the denial of handicapped people access to firearms. Just throwing that out there. It also talks about 18 to 20-year-olds aren't allowed to purchase handguns. We'll get to 18 to 20-year-olds in a separate video. I don't think that's going to uphold because 18 to 20-year-olds are part of the people of the definition of the Second Amendment. And it goes on to say the person has to be found, if the person is found lacking the essential character or temperament, here's the language. If the person is found to be lacking the essential character or temperament necessary to be entrusted with a firearm. Again, no liberal in New Jersey, no anti-gunner in New Jersey is going to trust any Trump supporting, any DeSantis supporting, any Republican, any pro-gun, any Second Amendment supporting person. They think all of us have no good temperament, have no good judgment. We're all really smart. None of us can have prestigious jobs or fancy academic credentials. We're not smart enough, so they say, right? None of us who are involved with this video right now would be qualified. By the way, I also want to add one other thing to show you how absurd this is. They also point out that any person, and this is a danger, any person named to the terrorist watch list maintained by the Terrorist Screening Center administered by the FBI, not allowed to have a gun, not allowed to get a gun, not allowed to carry a gun. Now here's the kicker. That watch list, that terrorist watch list, is what the anti-gunners have been trying to put all America. As I see it, they want to put all Americans. If you're a Trump supporter, if you're a DeSantis supporter, if you're a Second Amendment supporter, if you like guns, right? We saw that recent the press package out of the FOIA about a month or two ago, where basically if you talk about the Gadsden flag or any of these things, Gadsden flag, guess what? You are a terrorist in waiting. So anyone, all it takes is Joe Biden or his buddies to put you on the terrorist watch list with no hearing, no trial. You don't even know about it. They put you on that list. You're not allowed to have a gun in New Jersey. You are banned because you're on a watch list. And again, there's no due process. There's no adjudication. You can't try. No, nothing. It's entirely discretionary on the part of some government official that has the opinion that you should be on the terrorist watch list. And trust me, again, I think the anti-gunners and the Biden administration would put anyone that supports the Second Amendment on the terrorist watch list, and anyone that supports Donald Trump or is an election denier, whatever that means, would also be on that list. Okay, folks, I know this is a long, detailed discussion. We got really geeky on some of the stuff, but it's very important for you to understand. Anytime you see a carry law in New Jersey or anywhere else that sets forth the criteria and rules that are not objective, definite, and narrow, watch out. Very dangerous. And remember, don't forget the footnote in Nysurpa versus Bruin that also points out that any application process that is too long or too expensive to the gun owner also likely violates the Second Amendment. And I also saw a reference in this statute that says that they can take up to 90 days and maybe with a 30-day extension to determine whether or not you are good enough to have a firearm. I think that's probably too long. I think, again, for the first 6 or 7 months, while New Jersey is transitioning to the new system, there will be a lot of leniency on the part of courts toward places like New Jersey to get their act together. But there's going to be warning signs. And again, if they start doing some of the nonsense that Nysurpa versus Bruin said they can't do, which I just read to you, watch out. I think the courts are going to step up and prevent that from occurring. But only time will tell exactly what will happen. Okay, I hope you learned something here. And again, if you haven't subscribed to the Four Boxes Diner, please do so. And we'll see you again here at the Four Boxes Diner.
Orders up. Table 2A.